Greetings and welcome to In the Face of Resistance, Advancing Equity in Higher Education. Over the years, the institutional policies, practices, and discourse surrounding affirmative action have changed drastically. And with the impending Supreme Court decision, there is renewed attention to this issue that continues to have a significant impact on how institutions of higher education work for diversity, equity, and inclusion on their campuses. No matter the legal ramifications of the Supreme Court's impending decision, the lawsuits that may follow, institutions must be prepared to continue to lead for DEI in higher education in the face of resistance, whether local, legal, or socio-political in nature. This webinar will begin with a brief socio-historical framing of affirmative action and transition into a panel discussion between administrative leaders and scholars. Our panelists will discuss race-conscious admissions policies, how they responded to affirmative action bans, and the lessons that they learned along the way. Hi, my name is Keenan Colquitt. I am the program lead for the Diversity Scholar Engagement with the National Center for Institutional Diversity, NCID, at the University of Michigan. I facilitate programs, events, and initiatives such as the Diversity Scholars Network that are committed to advancing understandings of historical and contemporary social issues related to identity, difference, culture, representation, power, oppression, and inequality as they occur and affect individuals, groups, and communities and institutions. We are proud to sponsor this event in collaboration with the University of Michigan's Office of Diversity, Equity, and Inclusion, the Anti-Racism Collaborative, Center for Social Solutions, Democracy and Debate, and the National Association of Diversity Officers in Higher Education, NADAHE. On behalf of myself, NCID, and all of our sponsors, we welcome you. We begin this event with a land acknowledgement. The University of Michigan is located on the traditional territory of the Anishinaabe people. In 1817, the Three Fires Confederacy made the largest single land transfer to the University of Michigan. This was offered ceremonially through the treaty at the foot of the rapids. Through these words of acknowledgement, their contemporary and ancestral ties to the land and their contributions to the university are renewed and reaffirmed. And now, our event. We'll begin with an introduction from Paulette Gainberry Russell, JD, who will be greeting us via video today. At the conclusion of her comments, we will hear from Drs. Nancy Cantor and Earl Lewis. Dr. Cantor is a chancellor of Rutgers University, Newark, and an internationally recognized leader emphasizing diverse, cross-sector collaborations and leveraging publicly engaged scholarship to advance racial equity and equitable growth in colleges and universities. Dr. Lewis is the Thomas C. Holt Distinguished University Professor of History, Afro-American and African Studies, and Public Policy, as well as the Director of the Center for Social Solutions. Dr. Lewis co-chairs a presidential initiative, the Inclusive History Project, which is designed to study, document, and engage the U of M community in understanding the university's history with respect to diversity, equity, and inclusion. And now it is my pleasure to introduce Paulette Gainberry Russell, JD, for opening comments. Gainberry Russell was elected president of the National Association of Diversity Officers in Higher Education in March 2020. She is a leading national voice and sought-after presenter on issues related to diversity, equity, inclusion, and justice in higher education and beyond. Gainberry Russell retired in August 2020 from Michigan State University, where she served as senior advisor to the president for Diversity Emeriti after more than 20 years advising on diversity and inclusion efforts at the university. So, with no further ado, we will now hear from President Gainberry Russell via video.
Good afternoon. I am Paulette Gainberry Russell, and I am excited to welcome you to today's important conversation titled In the Face of Resistance, Advancing Equity in Higher Education. As president of the National Association of Diversity Officers in Higher Education and a former senior diversity officer at Michigan State University, I have a very real day-to-day sense of why today's discussion is so important and critical at this moment. On October 31st, the U.S. Supreme Court heard 5 hours of oral arguments in 2 cases regarding the use of race-conscious admissions policies. Since 1978, in the matter of Bakke versus the University of California and subsequent challenges, the Supreme Court has held that diversity is a compelling interest and that carefully constructed admissions policies can consider race as one of many factors in the admissions of students. However, conventional wisdom is that this court will likely overturn prior precedent and find that race-conscious admissions is impermissible. The ruling is expected most likely this June. In an op-ed published on March 21st in Inside Higher Education, I stated that Nadahi disagreed wholeheartedly with the notion of removing a key tool to ensure campus diversity. However, it is imperative for chief diversity officers and practitioners to use resources to help prepare their institutions for a fully race-neutral admissions era that will extend well beyond undergraduate admissions offices. Since these 2 cases were heard by the court, there has been a heightened intensity of various states introducing legislation that is intended to dismantle generations of efforts to advance diversity, equity, and inclusion in higher education. Nadahi has spoken out publicly against these measures, and we continue to assess the potential impact the various bills may have on colleges and universities and on those who lead and influence this work in higher ed, many of whom are members of Nadahi. What we do know, ongoing concerns related to the need for more equitable and inclusive colleges and universities require intentional effort if we are going to continue our work to create what we value and expect in higher education: increased diversity, more equitable and inclusive campus communities. But we need to develop strategies to continue the work we are doing, which is why this event is so important today. We have assembled an esteemed panel of scholar administrators who can provide wisdom and insight that is so needed in today's socio-political context. Nancy Cantor, Chancellor of Rutgers University, Newark, will open with some framing remarks, and then we will have a panel moderated by Earl Lewis, who is the Thomas C. Holt Distinguished University Professor of History, African American and African Studies, and Public Policy, and Director of the Center for Social Solutions at the University of Michigan. I will add that last month, Earl was honored at the White House by President Biden with the National Humanities Medal. Congratulations, Dr. Lewis. Our esteemed panelists are Sylvia Hurtado, Professor of Education in the School of Education and Information Studies at UCLA. Wade Henderson, Principal of Wade J. Henderson, LLC, and Tabby Chavez, who is the Vice Provost for Equity and Inclusion and Chief Diversity Officer at the University of Michigan. I am pleased now to turn the program over to Nancy Cantor. Chancellor Cantor is recognized nationally and internationally for her leadership in emphasizing the role of universities as anchor institutions in their communities, especially by forging diverse cross-sector collaboratives and leveraging publicly engaged scholarship to advance racial equity and equitable growth. She previously served as Chancellor and President of Syracuse University, Chancellor of the University of Illinois at Urbana-Champaign, and Provost at the University of Michigan. While at Michigan, she was closely involved in the university's defense of race-conscious admissions in the cases Grutter and Gratz, decided by the Supreme Court in 2003. Thank you, Chancellor Cantor, for your participation in this webinar today.
Thank you. So in providing a historical framing of the trials and tribulations surrounding affirmative action, I want to highlight 2 themes that have been ever present over the 45 years since the Bakke decision: that of equity as reparative justice on one hand, and diversity as beneficial for all on the other hand. In debates, court rulings, state actions, and national dialogues, there's been a constant push for and pull back from a reparative framework in which the focus is specifically on equity and racial justice, taking down what Gary Orfield calls the walls around opportunity that have sidelined students and whole communities of color for so long. The reparative justice framework stands sometimes on its own as a rationale for taking affirmative action in education, employment, and voting rights cases. While at other times, especially in the context of higher education, it's seen as a necessary path to achieve the compelling interest of the educational and societal benefits of diversity writ large. Still, at other times, it is explicitly sidelined, often expressly to assuage a white majority backlash, so that the compelling interest of diversity for all must be argued in and of itself, by itself, disentangled from our national history of injustice and the continued systemic inequities that realistically impede full participation. And that reality and the backlash it generates continues to this day, reflected in the legislative action in state after state on DEI, and in the court's ruling on cases dealing with plans to diversify K-12 districts or redraw voting maps. Most relevant to our discussion today, this reluctance leaves us with the question of whether it is really possible to achieve the educational benefits of diversity for all without dismantling the systems that persistently sideline some. Do we need to reckon in order to equitably move forward? As my colleagues on this panel consider that path forward, I thought it might be useful to first review the various ups and downs of affirmative action over the last 45 years, starting, of course, with Justice Powell's decision in Regents of the University of California v. Bakke. Powell's arguments in Bakke not only set the legal precedent at issue today in the Harvard and UNC cases being adjudicated by the Supreme Court, but it also set the stage for decades of debate to follow, as he explicitly repudiated the use of a reparative framework as a rationale for affirmatively taking race into account in admissions decisions. Powell, in rejecting a reparative rationale, said, and I quote, "Hence, the purpose of helping certain groups perceived as victims of societal discrimination does not justify a classification that imposes disadvantages upon persons who bear no responsibility whatever for the harm the beneficiaries of the special admissions program are thought to have suffered." At the same time, Powell argued for a narrower consideration of race as a plus factor, along with other characteristics of an applicant, explicitly in order to support the compelling interest of achieving the pedagogical benefits of a diverse student body. Drawing on the experiences of Bill Bowen, then president of Princeton, Powell pointed to Bowen's assessment that, and I quote, "A great deal of learning occurs informally. It occurs through interactions among students of both sexes, of different races, religions, and backgrounds, who come from cities and rural areas, from various states and countries, who have a wide variety of interests, talents, and perspectives, and who are able, directly or indirectly, to learn from their differences." While his argument set an important precedent for race-conscious admissions, one that would be used repeatedly in subsequent defenses of affirmative action, it also set clear guardrails of strict judicial scrutiny of that compelling interest, as well as the need for narrow tailoring in the methods used to effect it. Interestingly, and often forgotten, are the arguments of four of the other justices, Brennan, Blackmun, Marshall, and White, who agreed with Powell on the plus factor approach, but also argued strongly that a reparative framework was constitutional. They wrote that the, and I quote, "articulated purpose of remedying the effects of past societal discrimination is, under our cases, sufficiently important to justify the use of race-conscious admissions programs where there is a sound basis for concluding that minority underrepresentation is substantial and chronic, and that the handicap of past discrimination is impeding access of minorities." As such, and in taken as a totality, I would say that the various arguments in the Bakke case laid out the landscape of considerations, both pro and con, in the pursuit of equity and diversity, and the decades that followed have continued to unpack this landscape. Most prominent in the unpacking of arguments since Bakke has been the affirmation in a series of cases from Grutter to Fisher too of narrowly tailored race-conscious admissions in recognition of judicial deference to universities' pursuit of those educational benefits of diversity for all. A key feature of the arguments in all of these cases that we should keep in mind as we consider how to advance equity going forward is the substantial database reaffirming the public benefits of education in a diverse setting, including producing more engaged, inquisitive, and tolerant citizens for our pluralistic democracy. This public-spirited goal was very much at the heart of our defense of affirmative action in the Grutter and Gratz cases at Michigan, as outlined by Pat Gurn and colleagues in the collection of essays written after the O'Connor decision entitled Defending Diversity, and drawing directly on the experiences at Michigan in pioneering the intergroup dialogue program. As we again fast forward to today's debates, it seems relevant to draw a line from that argument in Grutter and Gratz to the current work of scholars like Scott Page, arguing that there is a diversity bonus to be reaped when individuals learn to fulsomely interact in diverse teams, pursuing innovations in a knowledge economy. Moreover, building off what might be called a business proposition for diversity, linking full participation to a prosperous society, I'm reminded of how consequential the corporate and military amici briefs appeared to be in Justice O'Connor's opinion in Grutter. As Jeff Lehman noted in his essay in Defending Diversity, the corporate briefs, and I quote, make clear that the skills needed in today's increasingly global marketplace can only be developed through exposure to widely diverse people, cultures, ideas, and viewpoints. And the military brief sounded a similar note, arguing that a highly qualified, racially diverse officer corps is essential to the military's ability to fulfill its principal mission to provide national security. O'Connor, writing for the majority in Grutter, then extended the compelling interest argument in what I believe to be a critical direction, arguing that the very legitimacy of American institutions is at stake. She wrote, and I quote, because universities and in particular law schools represent the training ground for a number of the nation's leaders, the path to leadership must be visibly open to talented and qualified individuals of every race and ethnicity. In other words, although the thrust of O'Connor's decision was totally in keeping with Powell's emphasis on the educational benefits of diversity, she extended the compelling interest argument, as Jeff Lehman suggests, and I quote, to incorporate not only pedagogic interest, but also an interest in democratic legitimacy. In so doing, I believe she raises the question of how institutions can realize the benefits of diversity without addressing the obstacles that systemically sideline some groups from journeying along that path to leadership. This is a key question to which I will return, one that brings us full circle to the links between a reparative approach and the compelling interest of diversity writ large. Before considering reparative justice as part and parcel of equity, the elephant in the room is the resurgence of colorblind doctrines on full display now in states across our country. As Jeannie Gerson noted in her piece entitled Education After Affirmative Action, Chief Justice Roberts has famously argued that, and I quote, the only way not to discriminate is not to discriminate, countering the words of Justice Blackmun in Bakke, who said, in order to get beyond racism, we must first take race into account. There is no other way. A preference for colorblindness has always been at the core of the court's thinking, even when arguing for narrowly tailored race-conscious solutions. As civil rights attorney Elise Boddy noted, and I quote, Justice Powell argued fairly explicitly in Bakke that broadening affirmative action would be racially divisive because it would cost whites as a group access and power. And as if to prove the power of that white anxiety, California followed on the heels of even the narrow rendering of race consciousness in Bakke with Prop 209, banning all consideration of race in admissions, as did Michigan with Proposition 2 in 2006 after Grutter, and 10 states in total have banned affirmative action to date. Moreover, as Catherine Mangan documents, the experience of California and Michigan offers sobering news in the quest to enroll a racially representative student body with race-neutral alternatives. Similarly, an extensive study by Tony Carnevale and his colleagues at the Georgetown Center on Education and the Workforce documents how, and I quote, banning race-conscious affirmative action will make it impossible for selective college admissions to mirror the growing racial diversity in high schools, even as their data suggests that class-conscious alternatives could allow such institutions to partially claw back their current levels of diversity in some cases. Interestingly, as an aside point on the debate between race and class-conscious affirmative action strategies, Carnevale notes, and I quote, "Our models made one thing very clear. The most effective way of increasing socioeconomic diversity at selective colleges is to consider race in the admissions process, not to ignore it." As Earl wrote in Defending Diversity, and I quote, "The debate about affirmative action in the United States is fundamentally about how to reconcile the tension between the need to include and the desire to limit that inclusion. And that very desire to limit inclusion, taken sometimes to violent extremes, as in the chants of the Charlottesville demonstrators in 2017, 'We will not be replaced,' is only heightened of late in the face of what demographer Bill Fry documents as a diversity explosion, raising questions and perhaps fears as to whether demography is destiny. We see this fear reflected in the anti-DEI legislation introduced in 18 states to date. As these DEI debates underscore, there is very real reluctance to talk about history and systemic racism, or to embrace assertively the fastest growing populations in our midst, along with continued adherence to race-neutral solutions to reap the benefits of diversity, which Justice Ruth Bader Ginsburg called out as nothing but a pretense in her dissent in the first Fisher case, noting that, and I quote, "Only an ostrich could regard the supposedly neutral alternatives as race unconscious," unquote. Nonetheless, as difficult as it is to imagine how a country built de jure and de facto on racial classifications can see a colorblind path forward, that option is still very much on the table, not only in court renderings and local debates about higher education, but also in determinations about the legality of efforts to promote equity and integration in public schooling, in employment, in contracting, and in voting rights cases. Most relevant to our discussion here today, as Gary Orfield outlines in detail in his new book entitled "The Walls Around Opportunity: The Failure of Colorblind Policy for Higher Education," it is more and more evident that enrolling and supporting a representatively diverse student body for success will require universities to reckon with and work to dismantle the host of obstacles in K-12 education, including under-resourced schools segregated by race and class, that sideline so many talented students. As Earl and I wrote in our introduction to the first volume in our series on Our Compelling Interest, The Value of Diversity for Democracy in a Prosperous Society, we cannot simply presume progress, especially as patterns of residential, educational, and economic segregation have in many ways hardened over decades. Even in the face of a legal retreat to colorblindness, we will all need to look to a set of race-sensitive policies, from expansive outreach and collaborations with our K-12 partners to new ways of evaluating admissibility to comprehensive financial aid attuned to the realities of the families and communities in our midst. We will need, as Lonnie Guarnier wrote some time ago, to interrogate meritocracy in higher education, seeing the assets of lived experiences that contribute to excellence at a much wider range of institutions and for a much broader set of students than are typically under discussion in these cases. We will need to creatively move beyond narrow standardized measures known to have disparate outcomes to ways of identifying potential grounded in the diverse experiences that students can bring to the table, ironically hearkening back to the original arguments about the value of diversity for the richness of education. It is hard to promote colorblindness in a society that from its founding has been built on color consciousness And as O'Connor noted in Gruder, and as Earl and I asked again, and I quote, is the perceived legitimacy of American institutions, from those that educate to those that adjudicate, from those that promulgate free expression to those that safeguard our security, at risk when so many are left behind in the land of opportunity? Or to say it another way, we can't reap the diversity bonus without explicitly redressing decades of systemic discrimination in order to truly bring everyone to the table on equal footing. And in this regard, numbers really matter. Without a critical mass, not even the aims articulated in Bakke, Gruder, or Fisher II can be realized, as the University of Michigan noted in their amicus brief and the current cases from Harvard and UNC. Referring to the decrease in Black student enrollment at Michigan since Proposition 2 went into effect, they noted that, and I quote, this reduction in diversity not only denies students the educational benefits of a campus, it negatively affects students' well-being. Fully 1/4 of the underrepresented minority students surveyed indicated that they felt they did not belong at U of M, a 66% increase over the last decade. In other words, numbers really matter. Hence, we've come full circle to the question of how much collective will there is to recognize shared fate and to understand that e pluribus unum cannot be achieved without taking down the walls around opportunity, no matter how much anxiety that causes for the long-favored groups. This is true when you frame the road forward as equity and reparative justice, or about diversity and educational benefits, or about institutional legitimacy, which one could argue combines them all, as we know you can't get the numbers that translate to both legitimacy and educational benefits without some reckoning with systemic realities. Somewhat ironically, the record of opinions from the Supreme Court, starting with Bakke and moving through Fisher II, in many ways brought us to this day. As I would argue, that racial reckoning was never too far from consciousness in those decisions, even if, as Elise Boddy has written, and I quote, as in Gruder, such a shift would necessarily require the court to recognize a new brand of compelling interest, promoting the inclusion of racial groups that historically have been abandoned at the margins of society. This is not likely a shift that this court will make, and they may well shift further from it altogether. But it is a shift that we must find ways to make ourselves, be it through race-sensitive commitments to geography and community, along with expanded notions of where we see excellence and how to reap that bonus. For as Gary Orfield says, and I quote, a society which fails to develop the talents of a vast share of its people is a society with wasted possibilities and a threatened future. Or as Stella Flores notes in her commentary in Gary's volume, and I quote, the move forward is not to deny color, language, and culture, but instead for colleges and universities to take into account these factors as assets for a multiracial and globally competitive nation. And I would add, no matter what the court decides, we have a public responsibility to make this move forward. I'll now turn over to Earl and the panel.
Nancy, thank you. Thank you for that brilliant assessment of what's at stake. Your framing is an effective starting point for the conversation that is to follow. Many of us have long argued that while diversity is key to crafting and preserving a prosperous democracy for all, the use of affirmative action, while important, has also avoided the central question of reparative racial justice and inclusion. The Harvard and Chapel Hill cases draw those distinctions and shine a spotlight on the implications. They remind us, yet again, that history is not linear and anything worth fighting for is, quite frankly, worth fighting for, especially the battle that distinguishes equity as compared to equality. Today, our goal is threefold. One, to discuss the implications of a negative decision, either full or partial, in either of these two cases. 2, to set parameters for a lawful response while refusing to signal full retreat from the core mission of providing opportunities for all in a society that is not and has never been colorblind. And 3, to hear from you, those of you who are attending. I am happy to be joined by 3 friends and colleagues, each with a wealth of experience. Tabby Chavis, Wade Henderson, and Sylvia Hurtado. Tabby, as you have heard, is the Vice Provost for Equity and Inclusion, Chief Diversity Officer, and a Professor of Education and Psychology at the University of Michigan. She leads the University of Michigan's Office of Diversity, Equity, and Inclusion, ODE, and working with ODE unit leaders and staff on initiatives for students, staff, and faculty, as well as collaborations and partnerships with campus units and local community and national partners. Wade Henderson is the principal of Wade J. Henderson, LLC. Henderson serves as an advisor to major corporations and nonprofits on matters relating to civil and human rights. He currently serves as senior advisor to the Leadership Conference on Civil and Human Rights and the Leadership Conference Education Fund, organizations he previously led for more than 20 years. Sylvia Hurtado is a professor of education in the School of Education and Information Studies and director of the Higher Education Research Institute at UCLA, which she's done so for over a decade. She's written extensively on diverse students' college experiences, the campus racial climate, and higher education equity and inclusion. Her early engagement as a first-generation college student led to roles in college admissions, graduate admissions, and student support, as well as her developing interest in higher education as a field of study. Concluding today's program will be my colleague, Elizabeth Cole. Liz is the director of the National Center for Institutional Diversity and the University Diversity and Social Transformation Professor of Women and Gender Study, Psychology, and Afro-American and African Studies at the University of Michigan. And she also serves with me as a co-chair of the Inclusive History Project. Just a little brief about the run of show. We will talk among ourselves for about 45 or so minutes, and then we're going to open it up to you for 20 or 25 minutes or so. Would ask at that time that you use the Q&A function to pose a question, and we will route those so that they can be addressed. And then Liz will close us out, and our goal and aim is to conclude by 3 p.m. So let's get started. We start by saying each of you has played key roles in American higher education's task of defining the importance of diversity for a prosperous democracy. General question. Do you think affirmative action, especially race-conscious policies, have been effective tools for the nation? And if so, why?
Perhaps I'll jump in if my
Thanks,
colleagues don't mind. Thank you, Earl, and thank you for the invitation to join you for this important conversation. Let me start by saying I thought Nancy Cantor did an extraordinary job in outlining the rationale and history of affirmative action and race-conscious policies. I think to gauge the effectiveness of these programs, one need only look at the flagship universities in the 10 states that previously had race-conscious admissions programs in place, but lost them through referenda or attacked by the state legislature. University of Michigan is a case in point. In 2021, the University of Michigan's minority undergraduate, Black undergraduate enrollment dropped to 4% from 7% in the year 2006, which was the year that Michigan first banned race-conscious admissions. Both Michigan and the California systems filed an amicus brief in the cases before the Supreme Court, arguing that without affirmative action programs, the likelihood of achieving diversity on campuses was virtually impossible. The truth is, the statistics speak for themselves. Now, the opportunities that students of color have had to develop their lives and the academic experience that they would not have had without affirmative action programs obviously should be taken into account. But the enrichment of the entire student experience for those students who are exposed to affirmative action programs and the diversity they bring is also worth noting. And I'll stop there, let my other colleagues speak, but I have much more to add to that conversation.
We'll come back. Sylvia.
Well, I have to say that like our colleagues Bowen and Bach found in following up all the admits that have been some of the first recipients are actually admits as part of affirmative action, extremely successful group. And I would not be a full professor today if an admission officer back in the 1970s took a chance on this Latina from a predominantly minority high school to come to Princeton. And so I have to say that a lot of us who are here today in academic positions and leadership roles, scientists, et cetera, are here because of affirmative action. And in other words, really thinking about how we would make contributions and how we were actually neglecting talent.
Debbie, you want to chime in?
Echoing my colleagues, I won't repeat their terrific points, really beautifully covered, but we'll just emphasize that as a broader social tool, that affirmative action has been beneficial in the society in higher ed alone, not only in higher ed, but in many organizational spaces. And in higher ed alone, between the late 70s and the last decade, that enrollment of underrepresented minority groups in higher ed has gone from between 40% to doubling that participation, and participation in elite education, although we're having challenges now, has benefited from those race conscious policies. And since we mentioned Michigan as a natural experiment, I call it, and in showing the kind of utility of race conscious policies, that not only has there been a challenge, even though it's trickling, the numbers are trickling back up very, very tinily from the more dramatic drop post what we call Proposition 2, that's our affirmative action policy in Michigan. That trickling back up is in the context of immense efforts to address financial aid, programs and foci that engage socioeconomic issues. And so a piece of this message is not only have race conscious policies been an effective tool, but that they are insufficiently, as the amicus brief from our institution showed, that other forms, other foci on socioeconomic status, for instance, are not adequate substitutes for focusing specifically on race and including race. And in fact, policies that focus on socioeconomic status that don't include race, and lots of terrific higher ed scholars have begun to show this in many different kinds of systematic ways and empirical research. Not only will there be no racial gains, there could actually be undermining of racial gains or racial regression. So race conscious tools have been critical and unfortunately are continuing to be at risk.
Thank you. So here we are, and as Paulette noted in her introduction, we expect the Supreme Court to rule in some form or another no later than this June regarding the Harvard and the Chapel Hill cases. Wait, I'll come back to you. It strikes me that the Supreme Court has several options regarding how to address Harvard and UNC. What do you think are the various options before the court? You're on mute.
My apologies. In looking at what the court might do, of course, it's all speculation, and we know that. But I do think that speculation in this context is helpful in planning for the future. So I'll take my hand at that. Look, I think there are perhaps three possibilities, and I'm really stretching it. Of the three, one is highly unlikely and will not, in my view, stand a chance. But let's talk about it. The first option is that the court might choose to uphold the status quo. Perhaps even going back to Justice O'Connor's remarks in Grutter and suggesting that these programs have at least a 25-year lifespan, which would take us to 2028 using the existing models. Now, that's highly unlikely. I know that. I think everyone here knows that. And as Nancy Cantor quoted in her remarks, Chief Justice Roberts' observation about the way to end discrimination is to stop discriminating, I think defines in a very pithy way what some feel, at least in that 6-member majority, about the use of race. We'll have to see. Certainly the skepticism expressed by that 6-member majority in the oral argument, with the possible exception, nuanced exception of Kavanaugh and Amy Coney Barrett, might suggest some possibilities. The second option, which I think is somewhat unlikely, but a restatement of more or less the current circumstance with a twist, which is that recognizing the value of diversity on college campuses, that goal needs to be enshrined and advanced. And every university has an obligation to explore the value of diversity on college campuses. But diversity, as I think Dr. Chavis mentioned, without some race-conscious efforts are going to be very difficult to achieve. I think the court may impose a new, more difficult standard on the use of race-conscious consideration, requiring an exhaustion of race-neutral approaches first, a showing that efforts were made to enhance diversity before authorizing a more limited, more targeted use of race in the admissions process. Now, how that actually plays out, we can talk about in more detail, but essentially it is an exhaustion requirement around race-neutral efforts first, before the court would justify under a very limited, more limited than exists today, examination of race. The third factor, of course, is to stop using race at all, race-conscious admissions, and bringing that to a complete halt. The effect of that reaches far beyond institutions of higher education. It goes to the government's interpretation, for example, of Title VII in the employment context. It affects the way local jurisdictions remediate their fire departments and police departments in trying to pursue reforms for some of the problems that we have seen nationwide. That ban, which I think we all have concern may in fact occur, will have broad implications that we perhaps should discuss, but I'll stop there. I think those are more or less the three options, but I think it is unlikely highly unlikely that the first is really on the table.
Great, thank you. Sylvia or Tabby, you want to add anything as you speculate about the future?
Not,
Go ahead, Sylvia.
no, I'll just say it's that, yeah, I agree with Wade that I would doubt. I think this court has a tendency to reverse everything and including previous precedent, because there's been more than one occasion where these issues have become before the court and they have not overturned affirmative action. But this may be the key turning point.
And I will just add that I think, even before, a decision in this case, I think people are facing speculation on the decisions that have made recently, and so feel that it could be overturned. But I think there have already been implications for higher education spaces across the country in terms of some institutions proactively planning to pull back, planning to pivot in ways that, so there are a lot of institutions spending a lot of time and energy focused on, alternative plans and enrollment, alternative plans in terms of things that relate to student life and experience, given some of the climate impacts that this discourse and the questioning around the benefits, or the re-questioning around the benefits of diversity have had. If Dr. Granberry Russell were here, that she couldn't be here, but you were benefited by her video remarks. she would describe the fact that, diversity offices across the country have been reaching out to her organization in concern. Offices are closing, in response to the legislation that was mentioned earlier across, anti-DEI legislation. So this type of decision, depending on, how it's written and how it's articulated, could embolden and empower those spaces that are already waiting to roll out, more aggressive legislation or new forms of legislation. I will also say that, this is not an unimportant kind of challenge that that's happening right now, because what happened, going back to speaking for Michigan and perhaps California too, I don't know, Sylvia, if it was the case, you could comment, that, after our affirmative action ban in 2008, that there was paralysis that happened, paralysis because of fear and anxiety. And so even though the actual law only limited two things, hiring or admitting because of race, or providing a financial benefit because of race, that there was lots of paralysis on lots of activity and action intended to advance racial diversity and representation. And so I think I'm feeling some of that same kind of deja vu in institutions kind of bracing themselves to like freeze. Although I'm also seeing some terrific indicators that some institutions are like, let's learn from these examples and brace ourselves to pivot in creative ways. So I hope we'll get to talk about that some in this discussion too.
Well, could I make just two quick points to underscore first what Dr. Hurtado said about the failure of this court to respect precedent. I needn't dwell on that, but I think the decision to overturn Roe versus Wade, the 50-year precedent, sort of indicated that this court is prepared to go rogue on any issue that it has had longstanding disagreement with, and this may well be that issue. And secondly, universities should be planning now in anticipation that the worst case scenario will occur, and that they are prepared now to begin implementing the extraordinary measures to blunt what might be the normal consequences of an adverse decision. For example, recruitment of new students is going to be absolutely essential to blunt the effect of a really adverse decision here. We saw that in the California and Michigan examples when affirmative action was stopped. We can anticipate that will likely be the case again across the country, and we should be preparing for that right now, just as an example.
Let's stay on this topic just for a second longer. Each of you has talked in some ways about the implications of an adverse decision, that is a negative decision coming from the court. You want to expound upon that? I mean, so one implication, of course, is this will ripple through a whole set of sectors, and as Ray alluded to at the beginning. Another implication, it could have deleterious effects on admissions at the most elite colleges and universities in the United States. I mean, what else? What are the implications of a negative decision?
I think I'll start with, I think building on Tabby's point, because California is also an early example of what happens when that tool is taken away. And in this case, it was not just race, it was also gender. Gender could not be considered in any form whatsoever for admissions. There was only one distinction that was a little bit different. If for federal priorities or interests, then the law wouldn't hold. So anything federally that could be introduced to support this was going to continue. And in fact, Native Americans federal designation, we determined legally that this was a federal interest, and therefore they did not fall under 209. Of course, there's the interest in doing everything for some groups, but let me say the immediate implications and then follow up on what institutions can be doing instead of the paralysis. There was paralysis at UC as well. In fact, our admissions at the most selective campuses, which is the highest implications are at selective campuses. Those that are very diverse and are less selective are not going to see that much change in their admissions. They serve those students. They've been developing programs for them, but it's the most selective. In this case, Berkeley and UCLA saw percentage cuts by half for African-American, Latinx, and Native American students. So you can expect that if you don't act, if you don't have an alternative, which developed fairly quickly after that, was really rethinking that. But institutions kept thinking, and unfortunately, if you keep doing the same thing, you're going to have different results. Well, you can't keep doing the same thing. You really have to broaden your conception of talent. And in fact, for a while at UCLA, I would say in those years where we were not being innovative in terms of thinking holistically or broadening conceptions of talent, we had a large number of African Americans on campus who were only in athletics. So another form of talent was being prioritized. And that, of course, contributes to stereotyping and all of that. And of course, they could be, let's say, exploited by the institution, unfortunately. So really, then the institutions that will be most affected of those more highly selective and those who have not broadened their conceptions of talent, thinking about the local context, the barriers that students have faced to get to college, their thriving, their striving, their opportunities to overcome adversity, and then focusing on the schools that have been under-resourced and really understanding what kinds of partnerships can be developed. I liked Nancy Cantor's broad notion of it really is about building partnerships, rethinking inequality more broadly. So it will force us to do that, but without action. And those are the most difficult problems to solve. So I think those are like key areas, and some institutions are beginning to think about, are there areas of economic mobility that we want to focus on for development and change the racial conversation to that. And so that might be useful to really think about. We can work with organizations, institutions, and where unequal resources are still pretty much part of this longstanding segregated system and history of discrimination.
Thank you, Dr. Hurtado. I think, Earl, there are a couple of examples that I would cite in the private sector using, for example, the Department of Justice as it examines some of the police departments around the country that are undergoing internal reform because of examples of widespread discrimination in the handling, for example, of police cases. Minneapolis comes to mind, Baltimore, in the aftermath of the Freddie Gray murder come to mind. The reforms that the Department of Justice sometimes imposes takes into account the racial admixture of the department and makes recommendations about filling positions in part based on race. Now, we recently saw in Memphis had a racial squad, in this instance, 5 police officers, doesn't determine appropriate behavior, but eliminating the use of race in its entirety would be detrimental to the ability to help achieve the reforms that everyone agrees are necessary. The Department of Education Office of Civil Rights, in its enforcement of Title VI, looking at, for example, issues of disparities in discipline at schools, or in other instances where race becomes a factor, trying to fashion remedies that don't take race into account may be particularly problematic. And at the very minimum, these policies will have to be rethought in light of the court's potential adverse decision.
And I would just jump in really quickly, Earl, to highlight, when I think about the interdigitation of the Supreme Court, decision and the anticipated kind of decision, and the wave of legislation that's happening at the state level across the country, that the implications, there are unique implications for elite or quote unquote selective institutions. But I think for our educational system more broadly, so at less selective institutions, there's implications for hiring, and the staff and faculty who are engaged with students the kinds of education, so if we're saying, I mean, because what's happening is erasing race. Well, let's erase race from a curricular perspective. Let's erase race from efforts to address and repair past discrimination and to leverage, and we're questioning whether that's beneficial to higher education or to education more broadly. And so, the K through 12 students who will be entering higher ed, whether it's through selective or less selective institutions, will also have been impacted by this kind of very, systematic and planful, way of, again, engaging this broader question of, is consideration of race in the society beneficial? Is it, and this kind of movement toward the colorblind that we were talking about in the beginning. So I think that this decision will kind of be a spark with a lot of other activities and efforts that are happening at the state level in ways that have implications from K through 12 or pre-K through 12 all the way through higher education of all forms.
Yeah, and listening to all three of you, one's reminded that we live in a moment where we profess with, well, some profess with even more urgency that the world is colorblind. But most of us live in a world where we know it's not colorblind. And so you end up trying to figure out how you reconcile the two ends of a spectrum. And it makes me go back. I mean, as preparing for this, I went back and read Thurgood Marshall's concurring and dissenting opinion in the Bakke case, and where Justice Marshall was clearly aware of history and the weight of history on the present, and as he anticipated the future. And in some ways, I think it's not just Marshall, Brennan and White and others also had a reparative frame as they were thinking about the ways in which law and the laws could be crafted. So I come back to some part of Nancy's address and wonder, in this moment where we can anticipate this court perhaps deciding that the diversity benefits argument, at least with a racial component, no longer has value. Could that actually be that spark you were talking about, Tabby, to energizing a new conversation, a new debate, a new set of activities around a reparative framework that was set aside for more than 45 years? Anybody want to jump in? Tabby, go ahead.
I like the framing. At these days, the optimism pessimism oscillation is up and down. So you're taking us on an upward path, Earl. I do think, I will just say, in my leadership space, that the outreach that's been happening, whether it's like within our conference across the country, that there have been leaders reaching out to each other to actually say, hey, how are we going to collaborate or connect? I think it's a great movement away from, a ruling has, Michigan, thought about what is going to happen to Michigan. We weren't collaborating with other institutions and at least in a visible way around, this is our challenge. We were thinking about our enrollment and our implications for our community, which is, understandable. But this issue is more than about one institution. This is about representation and access in higher education in our society, and all of the life chances and outcomes that are attached to that access and mobility. So I do think there has been already evidence. When I said there has been kind of bracing for retreat, there's also been, in my view, outreach for, hey, there's been a really concerted, aggressive and, cunning effort to highlight this and to miseducate the public about the basis of these policies or practices. How can we be creative and just as collective in our efforts too? And so that's been meetings of chief diversity officers all over the country. There have been presidents connecting with other presidents in ways that don't seem to be the kind of typical kind of process, as well as researchers and scholars who have been engaging in new ways. I mean, this is a space where we've always been kind of collaborative, but I think even in some new ways. So I do see some reason to feel as though there's something real being sparked, in response to what seems like one message that's out there right now. Can we be just as collective at countering that message and addressing that miseducation?
So I would say the 18 states that had segregated higher education systems and also have very poor school inequalities, that would be a key area for reparation, to really consider those institutions that are lower resourced, that serve very diverse communities, and have been committed to the uplift of those communities, as well as the schools that have been under-resourced. So I think those are opportunities. We do kind of have a reparative justice scholarship we're offering at UC. It's a Native American Opportunity Fellowship that now we're offering, which provides funding, free tuition, and fees over and above whatever a student qualifies federally. We're working with private foundations to offer scholarships for African Americans, and also we're beginning that process for Latinx students. So really thinking about how to marshal additional resources in different areas to focus on the important problem, which is really addressing the underrepresentation, the lack of resources, and certainly all the wonderful programs we hope we don't lose. We hope that some private foundations and some of our initiatives can work towards developing.
Yeah, Earl, I would just say, let me start by saying your Inclusive History Project is a testament to Justice Marshall's dissent in Bakke about the importance and relevance of history and its impact on today. And like you, in examining his dissent, I looked at what the University of North Carolina has done. It's one of the two cases currently pending before the court. It's important to have a sense of how their history has affected the current circumstance that the state faces. Dr. Hurtado mentioned the 18 states that were part of the old Confederacy and the lingering effects on their school system. And you see that very much in evidence in North Carolina, which has a systemic problem with its grade schools through high schools in limiting the courses that the university itself values from its student class. Black and brown students are excluded in a systematic way from many of the higher discipline courses that the university values, in part because of racialized tracking that limits the courses that students are able to take. Now, when you add that, which is a current day manifestation of the problem historically that we've talked about, to the rich history of North Carolina, you get a compelling justification for the reparative justice model. You know, University of North Carolina is the oldest public university in the country. It was chartered in 1789, built by enslaved labor, and yet admitted its first Black student in 1951 as a result of a court order. Now, I'm not going to go into the history of the state other than to say that exclusion and segregation were so important to the fathers and mothers of the state of North Carolina that they built a law school at North Carolina Central rather than integrating the University of North Carolina and admitting Black students. And the data between today and previously, 1789, is replete with examples of overt discrimination and an effort to avoid the responsibility for integration. If ever there were a state that justified the reparative justice model, North Carolina and the University of North Carolina are certainly a prime example.
Great. Thank you. I'm going to see if we can come back to this. I know there are questions already showing up in the queue, and we'll get to them in a little bit. Tabby and Sylvia both used the word paralysis earlier on, and thinking about what happened in California and Michigan, respectively, after referenda were passed. I think the word overreach, and Wade alluded to this in his initial comments. So how do we begin, no matter what happens, let's assume that in Wade's 3 scenarios, they won't affirm it as it currently stands. They may introduce even more guardrails and where there's even narrower tailoring than before. But more than likely, this is a court that will feel comfortable overturning the precedent and saying that race as a factor in college admissions should go into the past. But as you all have said, this has a cascading effect. So how do we begin to make sure that we don't overreact no matter what the decision is? I mean, my worry sitting where I am, when I was president of the Mellon Foundation, I once called, as Nancy knows, called a group of general counsels and others to the Mellon Foundation to talk then about Fisher, and it was after Gruner and Gratz. And 2 things that struck me. One, few of them actually knew the law than I thought would know the law. And so it sort of scared me when I was sitting there, how many of them understood this aspect of the law. And 2, they were willing to put up all kinds of defenses to protect their client, which was the university. But that also meant you were eliminating a whole range of degrees of freedom. And so how do we make sure, starting with general counsels, that as Wade noted, as we prepare for a decision, we actually don't also overreach? And Tabby, as a CDO, let me start with you.
No, I think this is a critical question. I mean, already there has been, immense time that is starting to be spent, again, some spaces starting with like, oh, imagining like that everything will have to be rehauled and retreaded and the like, and that's not the case. I would say even places, even spaces here where we've had, a ban since, more than a decade, almost a decade and a half now. I get questions regularly like, what will it mean for Michigan? And I was like, well, the same thing we're doing yesterday, we will do tomorrow in terms of the situation that we're in. We're in a pretty conservative version of the affirmative action ban too, actually very similar to California on race and gender, except for the federal loophole, which one of my colleagues calls the hypocrisy loop, that it's banned except if there's a risk for losing federal funding. But I would say it's starting with our institutional values. And one of the things that's been happening on our campus right now that I would encourage other spaces to do is to partner with your Office of General Counsel around messaging to spaces. I mean, people have, there's lots of energy put into misinformation to the public. And so how can we actually counter that just by by circulating good information? Like, what does this mean? What does it not mean? Is something that our general counsel office has been, engaging with schools and colleges, in discussions with, a number of the diversity kind of leaders in our different units across the campus and other spaces, that relate to admissions or hiring and the like too. So I would say that's one space, is having a partnership there around the messaging so that there is not unnecessary panic and concern that's based in inaccurate information. I think one message that, I felt really excited about in my partnership with them is emphasizing the fact that a court ruling is not synonymous with our institutional values. So regardless of the court ruling, that doesn't mean that Michigan doesn't value diversity, equity, and inclusion and racial representation and gender equity and representation, and that we have to include that as part of our messaging to avoid some of the paralysis. So I would say the other space is really engaging our general counsel's office. I think has had a journey over time with the fear and paralysis that came out of the affirmative action ban in Michigan, to really thinking about how do we partner to, work in ways that align with our values in ways that walk all the way up to the line, without crossing the line, that we're working from our values and then thinking about the strategies with an understanding of the law that will allow us to address that. And I would say that that is a space where there could be, in some spaces, an inclination to say, let's be as narrow as possible in our interpretations, or conservative as possible, rather, that could be broad or narrow, to avoid being scrutinized, to avoid being sued. And I would say our teams here discovered, like, oh, we're going to be scrutinized anyway. And we're probably going to be have inquiries and lawsuits anyway. So we might as well be working as proactively as possible, knowing that we can have a legally defensible process. So I would say, I can't say it enough, is to engage in partnerships with your Office of General Counsel. They're not just there to, like, for liability and protection and to keep us out of trouble. I would say many of those spaces are actively engaged and care about helping to use their knowledge and skills to help to partner. I would say an example has been, even across the past decade or so, different presidential, meaning US presidential administrations, have defined race neutral in different ways. Actually, in ways that have had implications for recruitment and and admission strategies, and a partnership with the General Counsel's office will allow units to be up to date with that information, and to think about then what that information means for strategy and tactics. So I mean, I think that's a space where we know now that we need that partnership up front.
So I'm sorry, Sylvia, did you want to go ahead?
Go ahead.
Okay. Let me build on Tabby's comments, because I do think, Earl, recreating the meeting that Mellon sponsored in the aftermath of Grutter is worth considering, but perhaps on a broader scale. I think that foundations like Mellon and Ford and others should consider a collaboration to sponsor a day or a day and a half meeting of players in this space to get a sense of what the court truly outlined and what options might exist. So targeted, of course, to general counsels at universities, and particularly those likely to have been most adversely affected in the short term, would be helpful. Bringing in representatives from the 10 states that have experienced the elimination of affirmative action over time to talk about what they're doing. Michigan, clearly UCLA, perhaps Berkeley, should all be there to talk about what they have done in response to their earlier challenges. Best practices, for example, should be widely shared as a way of getting a sense of what might be done as a broader collaboration, but an exploration of other options that might have been on the table in more limited circumstance, depending upon the state in which you live. So while Texas's 10% plan may not work in a state that has had a more diverse and integrated public school system, school systems that remain racially segregated today could perhaps benefit from that 10% plan, though not in the same way that one would hope the race-conscious admissions policies work. The same would be true of the Kallenberg economic analysis, which many are skeptical of because, of course, the widest array of those who are at the bottom of the economic ladder are white and not necessarily enhancing the racial diversity of the schools in which they are found. Nonetheless, that is likely to be put on the table yet again for further review. So my point, Earl, is that there needs to be a convening soon after the court renders a decision that brings relevant players together to assess where we are based on the most definitive interpretations of what the court has now required, examine best practices that may already be in place, and conjecture and thinking about how one responds beyond that, I think would be worth considering.
Thank you. Sylvia. Or Tech.
The only thing that I was going to loop back in, and so you can tell me if this resonates differently with you or not. Is that, yeah, I was just looking at some of the questions, and some commenters have highlighted, that in some spaces that the Office of General Counsel's orientation is not kind of to be aggressive and assertive, it's to be conservative, to avoid scrutiny and the like too. And I will say, that made me really kind of want to, signal and highlight a really important ingredient, and this is where community pressure and collective action can be really important, is that the institutional leaders have to name and define this as a value. So your president, your boards, the leadership, and also have an appetite and a stomach for the kind of resistance that will come up too. So there has to be an honest, discussion or assessment of, is this our value? Yes or no? And, because we know what's happening, by definition, there will be resistance to being out in front, continuing to advocate for this value. And so what is our appetite? What is our stomach for engaging that resistance? And so I would just say that has to be an honest space, and a space where the leadership, because that's where the General Counsel's office will take their lead from, what the institutional leadership, wants to do and has the stomach to do.
Absolutely right.
For CDOs and others, I would say that really is innovation, and really thinking about anything siloed is probably more likely to be attacked, because it can be identified as race specific. But on the other hand, I want to say that what we've all been working for is institutional transformation, to really embed DEI efforts in people's daily work, whether they're leaders, whether they're counselors, whether they're whatever work they're doing, to really have it embedded in what they do overall. And really kind of encourage, you can still work on equity issues. We do that. We talk about equity issues. You can still look at the data. You can still start developing programming that's going to be better suited to students' completion, for example, and or success into entry into graduate school. You can devise those kinds of things, and also could use a culturally responsive approach. You could still be culturally responsive. Now, you don't have to call it African-American or Latinx, but there are some culturally responsive approaches you can use. And so we've been trying to talk about these things. And you also have to continue to be, in terms of being equity-minded, systemically aware. There are constant power dynamics. We know that there are resources, unequal resources. All of these have to be thought of now more consistently in terms of devising some new plans and or working with individuals to improve what they do for students and also for the institution. So I think there's a lot of, I would say, even under 209, there's a lot of innovation, a lot of people collectively working towards trying to understand, rethinking how, teaching is going in STEM, for example, because the numbers are so small. We need to increase them in terms of underrepresented groups. We're working on that. And even in a race-neutral environment, we can devise programs that are better suited to these groups, but also will help all students to succeed. So I think this is the issue, is really difficult. For example, developing diversity plans that are distinct from the strategic plan of the institution should not happen. They should be well integrated. That way you move forward with a central strategic plan where efforts are considered as part of what the institution will normally do, I think. So anyway, that's my recommendation, is that we really have to continue the institutional transformation efforts, because our institutions are changing and our students are changing. In California, for example, 53% of the high school graduates are Latinx now. That's a very large number. We become an apartheid system if we don't serve in some way and find ways to actually serve these people that are, these are the next generation that's going to generate the economy for the state. And so all of those reasons, basically, it's all interconnected, and higher education plays an important role in making sure that we're advancing social progress, not just for individual social mobility, but for the uplift of communities.
Thank you all. I think Nancy, I'm going to call you back now, if I may, and we begin to move in, because there are a number of questions in the Q&A, basically about leadership and thinking, and this was alluded to both by Sylvia's last comments, Wade and Tabby before, and we think through. One question had to do about thinking about a negative decision from the Supreme Court and what burden that will place on our students on campuses, and how we prepare them is one thing for the institution to prepare to robustly defend what it does. But walking across and through spaces across campus, sometimes your body allows you to become the symbol of the change that others would like to avoid. And so how do we think about our students? I mean, if we think about this decision, where do we place students in the equation as the carriers of a post-Bakke world?
If I could jump in just quickly on that, Earl, I mean,
Sure.
I do a lot of work in the immigration space, and one of the things that I think is critical is that students' lived experiences get told, and that they tell their experiences and their connections to communities. I want to build on what Sylvia was saying in terms of not only spreading, using a sort of, as the USC people folks would say, a shared equity leadership model, spreading this throughout the institution, but spreading it in the community. I mean, I think one of the things that that this ruling will do is force universities to do what we ought to be doing anyway, in my view, and that is be anchor institutions in our communities, whether it's a region or a particular community, so that we have those kinds of ecosystems built that are, given the demographic changes, will naturally be embracing of a more extensive talent pool. And I think letting those students' voices be told, as I mentioned in my comments, numbers really matter, but one way to get numbers, even in some institutions that are hit by this, will be to have real embrace of broad communities where there are numbers.
Great, thank you.
You know, Earl, I thought Tabby underscored something that was extremely important, which is the value of the institution and how those values are expressed, particularly in the aftermath of an adverse decision. And students will certainly be rocked, both students that thought about coming to the institution as well as students who are there. And how those institutions respond to this setback is going to be important in reassuring these students of their value and their welcome in these institutions, and to be embraced by the existing leadership. Conveying that in lots of different ways is going to be important. Now, it is also important to recognize that when you eliminate that kind of racial diversity, you are denying students an opportunity for exposure and engagement at a level that affects leadership in the state going forward, as well as opportunities to be explored. And looking at the University of North Carolina, for example, I'm thinking about the value of diversity. North Carolina had 2 Nobel laureates, 54 Rhodes Scholars, and 32 of the state's governors went through the University of North Carolina. Denying students of color, African Americans in particular, given that history, it seems to me does not recognize the values that this university wants to impart. That's why I said earlier, Earl, that your study of inclusive history is important. And I would encourage other universities to consider the same, because this issue, in addition to being a matter of discussion by higher education, is also going to be a political issue in the states in which these universities are housed. And how these concerns are expressed And what is used to buttress how the university responds is going to be very important. And that's why these studies of inclusive history, in my view, are essential to fashioning remedies going forward.
Thank you.
I want to, really tag on to something that Nancy said in her framing remarks, which was, really thinking about, again, messaging to our community. And we have students, we have, transitioning students in, we have continuing students. We also have faculty and staff who have concerns about either, how they're viewed and framed in the context of these rulings and the like too. And so really thinking about messaging that really, reinforces what I think was at the heart of the scholarly work done, for the prior cases, which is diversity and excellence being connected, which really requires, re-emphasizing the reparative, historical, social inequality, but also the benefits of diversities, reinforcing the fact that regardless of this ruling, you weren't here in the first place only because of your race. You were here, and you weren't here because representing groups based on their representation in society is the right thing to do. It actually makes our institutions more intellectually and culturally rich. We're intellectually bankrupt if we don't have your lenses and perspectives there. I think, a adverse ruling will just feed kind of, that, the opposite. And I think that messaging has to, again, combine the historical justice lens with, it's not just the right thing to do, it is the thing to do for excellence. Connecting it to core mission, being able to show that by addressing this, we actually show improvements for, students across many different communities when we address inclusive pedagogy in the classroom, when we have different perspectives that are represented. I think, again, some of it will be just reinforcing in very explicit ways that messaging, again, because the push will be to make people feel as though, they're racialized beings and that they're only on their campuses or only being thought about, as prospective campus members because of their race. And we really have to counter that.
I would just say also that Nancy Cantor did a great job by appointing Earl Lewis, Dean of the Grad Division, to have that campus-wide conversation. And as part of the group, one of the first things we realized, there was a lot of things going on in different units. So one thing I think that committee did was actually help coordinate the conversation and messages, and only needed to add when there needed to be something campus-wide or refinement for what was going on. So it was a lot of things going on all across campus, and we didn't realize until we came together and really just say, how do we message? How do we make sure we're having these conversations with students so we could plan those? So I think it was a great example of an institution getting ready for a decision that the community needed to be engaged in and understanding more broadly, and in that education. Of course, students have their own groups, activist groups that were working on their issues, and to honor that expression as well. So it can be done. And I think we just don't realize what everything is going on across these institutions. And then we realize a lot of good things, a lot of good ideas, good conversations can be had.
Thank you all. There's a question in the queue, and I just want to frame it for a second, because as I read the question, and Sylvia alluded to, so in another point of my life, Nancy and Lee Bollinger, who was then president of Michigan, gave me the assignment of trying to keep the campus from coming apart as we were on our way heading to the Supreme Court. But that actually meant then bringing folks together, some of whom didn't always talk to one another, but creating context. And that's in part about a question about leadership. I mean, there are ways that you can begin to anticipate some of the issues, and there are roles to be played. But I was reflecting, there's a question, and I was reflecting on the Grutter and Gratz case where I think it was at the appellate level. The opponents to the University of Michigan's affirmative action strategy at that point finally conceded that all the students who were admitted were qualified. I mean, that always had been an argument that we were admitting less qualified students. They finally admitted that all the students were qualified. They took that off the table. What they came back and said, we just don't believe that race should be a variable, period. I mean, and that was sort of their anchor position. And so it was, and they didn't buy, in effect, the diversity argument at all. And in fact, they instead wanted to insert the colorblind argument as a central tenet, and to use Tabbitt's words, as their value. And I asked that question because as one of the questioners here, it seems that administrators of less selective universities are of the belief that the SCOTUS decision will only impact admissions processes of highly selective universities. Please provide your thoughts about the potential downstream consequences of a SCOTUS decision on less selected schools and on efforts to diversify professional school enrollments, especially law, medicine, and health. And so there's this interesting question because this questioner understands some aspects of the interrelatedness of both the undergraduate experience, but also the link to professional schools and pathways into the profession. So anyone want to jump in?
Well, I think the concern that the questioner posed about the impact of a decision on schools below those that are the most selective is absolutely right. I mean, I think this will have a profound impact on admissions across the board, because even in less selective institutions, there are still models that take into account the race of the applicant and the need to create some level of diversity and racial, quote, balance without necessarily putting a hard number on that or establishing a quota. But the way it looks, the way it makes you feel in terms of providing some level of diversity. I focus on North Carolina only because I looked at it most closely. But, and the university should be commended for having an 8% Black student population. But overall, the state has a 22% African-American population, and thus the level of progress has not been significant. What was most disturbing to me is that in 2021, there were only 95 Black men enrolled at the first-year class of about 4,500 students. So we're talking about a 2% of the class at the University of North Carolina being Black men. Yes, it's a selective institution, but I suspect that schools that are on the lower end of that spectrum are also going to be affected. And certainly this will be a conversation that permeates up and down the line with universities in thinking through how these schools respond. And this question of whether students feel as if they belong and whether or not they have been adversely affected by the racialization of the admissions process and the way in which it's discussed will certainly be affected by this, and will have to receive the kind of support that we've alluded to for these more selective schools as well.
Yeah, if I could just add to, I totally agree with Wade. I think one of the things that's really important is that, and I tried to say it in a way in my remarks, and that is that the whole colorblind ideology and approach becomes a sort of spreading, it has a spreading nature. We saw that in a lot of the Supreme Court cases around school desegregation, around various plans for changing, for integrating schools that were turned back. And in Gary's book, for example, it's very clear that a lot of sort of what Jim Anderson called in that book kind of natural practices, if you will, went into effect because people started thinking, yeah, we need to be colorblind. And so it spreads very strongly. I think the other thing that we have to watch for is that we have to partner, and I think there was a question to this effect, we have to partner with the corporate community in our regions. We have to really think about the external voices that can, on the one hand, support the kinds of things we're talking about for equity, and on the other hand, could retreat from them in this kind of a context. So that I think we have to remember that higher education is a lever for so much more than, quote, education. and it really spreads its impact very, very broadly, both up and down. And that's why I would urge the kinds of partnerships that institutions can make with community colleges, with K-12, with corporate entities in the region, so that you get a sense that there's a broad support. I mean, I think, I don't know if Earl and Sylvia would agree with me on this, but I think that the key things that got us Grutter were really the military and corporate
Absolutely.
briefs. And the military in particular had an enormous impact on that decision, I believe. And that's the kind of thing we need to have reemerge. We need to get those voices on the table.
Would totally agree with you, Nancy. And I think I saw Sylvia nodding as well.
I'm sorry, go ahead, Debbie.
No, go ahead.
I was
Follow
simply going
on.
to say, I think Nancy put her finger on an element that the conversation had omitted previously, and that is the role of the military and the corporate community. And those briefs, the amicus briefs that were filed in Grutter and Gratz, were incredibly powerful and made a huge difference. It's quite clear in the way the court interpreted these programs. Now, whether they will have the same impact, we'll see. But certainly in the aftermath of an adverse decision, both sets of institutions will be important and need to be at the table for conversations, whether it's the individual corporations that signed the amicus briefs or groups like the Business Roundtable and others who will make a huge difference going forward. This will have a real impact in how business interprets its own human resources challenges.
Anyone else before I transition to, in part where I wanted to transition, it can be argued that perhaps what's different in this moment as compared to the turn of the 21st century and as we headed into Grutter and Gratz is that there are new headwinds, if not headwinds, crosswinds. That DE&I and now a number of states itself is being challenged and questioned and perhaps even legislated out of existence. There are, on the corporate side, there are new and powerful opponents, including states, to the ESG, the environmental, social, and governance challenge changes that have been advanced by the UN and others. And that, so in the corporate sector is filling it in his own way. Colleges, universities, municipalities, schools are filling it as well. So one question is how we began to deal with the general blowback. I mean, regardless of what the court does, there's a general blowback, and I don't think we should leave this session without talking about it. So thoughts, what should we be doing? How should we be responding? What strategies may be in place or should be in place to deal with the anti-DEI, anti-ESG movement that is also gaining momentum?
I would just jump in and say, I think one area that I alluded to was collaborations of many types. And so there's messaging at the level of grassroots and beyond, so that, again, with the anti-DEI legislation, I would say routinely and regularly now, and fielding, even though I'm not in one of the states that has the legislation that's right now in a relatively protected moment, but an election can make a difference. So I say at the moment when asked about this, that there is active miseducation around like what the DEI work in higher education is. So that the assumption, and I say Michigan is a place where they're counting the number of DEI personnel that we have and saying with the assumption that some number is too much, that someone else who doesn't care about DEI gets to define. And two, that DEI work is, ideological, only indoctrinating people. It's only for a small group of quote unquote entitled communities and populations, when in fact the nature of the DEI work that's happening across the country is connecting to many communities, from first gen to international students to disability community and culture, including race, as a lens, but also the work in gender equity and preventing, sexual harassment and all of those efforts are work that DEI work is encompassing, that cross-cuts just about every single community and constituency on our campus. And that's not the message that's getting out there. So that's one piece, I think, is that collaboration around the messaging that this work is not, indoctrination work, and to remind people that saying we should erase DEI is just as ideological, as saying that we should care about it. And then to really, again, go back to making sure that the work of DEI is connected to core mission, so that it's not siloed and separated, that we're talking about what it means in the education space and the benefit of it, what it means in the research space and the benefit of it, what it means in terms of programs or community engagement and the work that many institutions do, particularly those with public mission. So I would say, at the informal level, messaging to our communities, I do a lot of just honest discussions with different groups informally on campus, trying to be proactive about fielding inquiries in ways that push back against efforts to get clickbait, we just want to know what your numbers are, versus you're asking the wrong question about what our numbers are. Really, you should be asking, what are we trying to do, and why are we structuring ourselves to do it this way? And who decides, in our case, on a campus of 50,000 people, that 140 people are too much, too. And so I think that there's some things that we can be doing as individual institutions, but also, are we creating spaces to bring, higher education institutions together? Higher education institutions, I was just at an event with funding agencies and thinking about how they can leverage their positions to create, with and partner with higher education institutions, professional societies, as well as institutions. And then, what was already, marked, really importantly is, industry and, organizations such as military. So are we doing that type of work? I think is where we need to go, because there is collaboration and concerted effort in the opponent side. I mean, it is not just happening accidentally, it's happening in a very planful and calculated way.
Yeah, and I want to jump on that and add to the notion of community engagement. Again, I want to circle back to that, and that is, there's a natural way to weave DEI work into that work, because there's an authenticity in, if you're dealing with community policing, or you're dealing with environmental justice, or you're dealing with economic mobility in a community, and you're doing public education, and you're doing publicly engaged scholarship, and you're engaged, and this goes back, Earl, to the notion of how do you have students feel comfortable given the pushback that is going to happen. I think we really need to reinforce that there's a natural support system and collaborative system that comes into play when faculty and staff and students are working with community partners on those kinds of on-the-ground issues. That naturally speaks to DEI as part of your mission, because then you are naturally dealing with what's happening that is systemically discriminatory. I mean, it's on the ground, it's there, and it's not something that gets assigned to a particular corner of our work. It's something that becomes very real, and surprising numbers of partners then get around the table and actually work on this kind of thing. So I think it's another avenue for having real impact in the face of the promulgation of colorblind, and it allows us to then go back to reparative justice, because so much of what that work does is bring that framework to the fore.
I think we need to partner along with the new civic engagement movement, because really it's politicians' way of not dealing with the hard, real problems is to attack universities on DEI. In other words, they construct an evil that really is not an evil, and avoid the real problems that need to be solved in our communities. And so I think we need to vote these folks out and vote these initiatives down. And so there's work for institutions to do, to work with young voters, to work with increasing our information channels so that we do ensure that we have voters. And in some states, the issues have been, the board of trustees, particularly, UNC is a great example where they have been, really resistant and whatnot. Well, those are governor appointed positions. So those positions need to change as well. And so if we work with our voters, I'm hoping institutions will be able to make a change because they're actually avoiding the real problems.
Mm-hmm. I think the initial response, though, has to be framed around communications because there is, right now, we're on the defensive insofar as sustaining DEI and ESG. And it's part of an attack based on wokeism and the notion that, states and liberal establishments are too sensitive to the sort of contemporary view of challenging issues. And I think we need a broader, more coordinated response. And I think that while I hope individual universities will address their own DEI issues, as they should, I think, again, in responding to this broader effort, I'm hoping the foundation and corporate community will contribute to the effort of creating space where there's a coordinated message based on empirical data that has been factored into account about how we push back. Because I think simply responding to this in an emotional way will not be effective and will not take us to where we need to be. So yes, I agree, Nancy, completely, and Tabby, I think your point, Sylvia, are well made. So I would recommend that.
Our time, unfortunately, is up, but let me ask each of you in 6 or 7 words, what gives you hope? What gives you hope? And so, Tabby, I'm gonna start with you.
Saying that the more things change, the more they can say the same. And one of my favorite mantras is 2 things can be true at the same time. And then those 2 truths are that there is a new version of an old attack, and with some new strategies and tools and tactics and players in the mix too. But I also think that at the same time that there is energy. I mean, the participation in today's event, I think, is one indicator that this is something that communities across, within and across our institutions care about. And I see, multiple indicators that we want to be revisiting our values, like approaching this not by reacting.
All right, 6 or 7 words, Abby.
Oh, yeah, 6 or 7 words. Yeah, so 2 things can be true at the same time. A challenging space, but lots of indication of energy and motivation to fight back.
Okay, thank you. Sylvia.
I would have to say what Cesar Chavez said and what Ibrahim Kendi has said is basically the moment you lose hope, the battle is lost.
Good. Wade.
This new generation that is beginning to emerge at many levels gives me great hope. And that is really what I'm counting on to help reclaim an America whose values are as good as its ideals. I want to see us in place. And I think it's that younger generation that's making a difference.
Great. And Nancy.
I guess I would say the unusual set of partners that come to the table in local work that is surprising and uplifting.
Right. Thank you all. And thank you for all the questions. And sorry we couldn't get to all of them. And Liz, you take us out.
Hi, everyone. We just have a few minutes left, so I want to say some thank yous and leave you with some takeaways. First of all, I want to thank all of our panelists today, Paulette Granberry-Russell for her opening, Nancy Cantor for her brilliant framing, Earl Lewis for his thoughtful moderation, and Tabby Chavis, Wade Henderson, and Sylvia Hurtado for their insightful comments as panelists. I also want to thank our co-sponsors, and those include the Office of Diversity, Equity, and Inclusion here at the University of Michigan, the National Center for Institutional Diversity, the Center for Social Solutions, and the Democracy and Debate theme semester. Those are all entities here at U of M. I also want to thank the National Association of Diversity Officers in Higher Education, also known as NADOHE. All of these organizations made this event possible. And then last but not least, I want to thank our planning and production team. This was a wonderful collaboration between CSS and CID and O'Day. They made everything flow seamlessly, and we really appreciate it. At NCID events, we usually like to close with a call to action. And so I get to outline some of the things that I heard in this panel that we could take with us to act on as we move out of this space. The first one is counter misinformation. We need to resist the paralysis that can result from overcorrecting when the ruling comes out. And to do that, we need to understand the law. Nancy Cantor talked about colorblind ideology spreading. So we need to share this accurate information to keep that from happening. And Tabby talked about how there might be an impulse to lay low to avoid scrutiny, but we're not going to escape scrutiny. So we need to do that thoughtfully and counter the misinformation. Secondly, we need to continue to push for access to and for equitable experiences within higher education for those who are from historically marginalized groups and those who have been excluded within higher ed. And we need to do that at every level. We've talked a lot about students, but we also need to think about access for faculty and staff. The third takeaway is that we can all offer support, space, and refuge for those who are directly affected as a result of changing policies and what Earl called general blowback. We had a lot of really important conversations here about the impact this potential ruling could have on students. We need to support them, and we need to amplify their voices so that they can be this effective and engaged next generation that Wade talked about. And then finally, we need to advocate, lobby, and organize to counteract these active efforts to undo progress. Push your campus leaders to articulate their values, push them to express them to students. We as members of university communities are in a position to hold our leaders accountable for living up to these values. So those are my quick takeaways, calls to action. I want to thank all of you for attending. This has been an amazing turnout today, and remind you that we'll be sharing a survey in the chat. I see it just came up, a reminder. And we've also put resources in the chat that are relevant to the conversation we had today. We will be reaching out to everyone who registered to share the transcript, including of Professor Cantor's speech. So let's take this good information, let's take this inspiration, and let's go out of here and do our work. Thank you, everyone.